Welcome, and I call this meeting to order. Welcome to meeting number 101 of the House of Commons Standing Committee on Government Operations and Estimates, also known as the mighty OGGO, the only committee that matters. Pursuant to Standing Order 1082 and the motion adopted by the committee on Monday, October 17, 2022, the committee is meeting on the study of the ArriveCAN application. Reminder, please do not put your headsets anywhere near the microphones, as it could cause potential ear damage to our very valued translators. Before I turn the floor over to Mr. Lafleur for his opening statement, last 20 minutes we will do committee business. We just need to approve a couple of budgets quickly. And then we have Mr. Bachrach's, I'll go to him first, please, just for his Canada Post motion, as he kindly pushed that back from last time so we could have our full time with Mr. Yiglik. Mr. Lafleur, we'll start with you, please, for your opening statement. Go ahead, sir.
Thank you. Good morning. Bonjour. Mr. Chair, I first want to acknowledge that this meeting is taking place on the traditional unceded territory of the Algonquin Anishinaabe people. En tant que directeur,
As Executive Director of the Professional Integrity Division at the Canada Border Services Agency, my responsibilities include providing an independent investigation function for the agency. My team conducts investigations into allegations of employee misconduct and provides management with reports of our findings to allow them to address instances of misconduct in the workplace.
le processus
The process of investigating allegations takes time, and it requires a systematic approach to ensure that all evidence is properly gathered and considered prior to final conclusions being made.
policies and procedures relating to internal investigations are issued under the authority of the Chief Security Officer of the CBSA and are aligned with the Policy on Government Security, which requires that we ensure that any significant issues regarding policy compliance, suspected criminal activity, national security concerns, or other security issues are assessed, investigated, documented, acted on, and reported to the Deputy Head and other investigative bodies as appropriate. I have been a security practitioner in the Federal Public Service for 15 years, working in the fields of intelligence, security screening, misconduct investigations, and security operations. During this time, I have conducted, directed, and overseen hundreds of administrative investigations, both relating to employee misconduct and as part of reviews for cause of employee security screening. Key to my current role is ensuring the integrity of investigations, procedural fairness, and due process for those under investigation. It is for these reasons that it would be inappropriate for me to speak to you about certain details or matters which remain under investigation. Comme le sait le comité,
As the committee is aware, the current CBSA investigation into allegations first brought forward by Bottler AA is still ongoing. I am therefore limited in what I will be able to share about that process. What I can speak about is our investigation process and investigations in general terms. I will answer your questions to the best of my ability.
Thanks very much. Ms. Block, we'll start with you, please, for 6 minutes.
Thank you very much, Mr. Chair, and thank you, Mr. Lafleur, for joining us today to provide testimony on what has become a very lengthy and complex study into not only the ArriveCAN app, but now some investigations that are taking place within the Department of the CBSA. I want to confirm that the preliminary findings, have these been made public?
they have not.
They have not been made public. So after President O'Gorman referred the Bottler allegation for investigation, were you the individual tasked with leading this investigation from the beginning?
I am the director responsible for conducting investigations within the CBSA, so me and my team, yes, were assigned this file
Right from the beginning.
from the beginning in November of 2022.
Thank you very much. In your opening statement, as you just made, you outlined that the investigative process, and I quote, the process of investigating allegations takes time and requires a systematic approach to ensure that all evidence is properly gathered and considered prior to final conclusions being made. If that is true, if that is important, Can you provide any rationale to the committee as to why President O'Gorman would imply to this committee that Mr. McDonald and Mr. Utano were guilty of misconduct? And this happened on January 18th of 2023.
So I'm not exactly sure which statement of the president you're referring to, but I can speak to my process and that we have not yet reached any conclusions relating to misconduct.
So do you think it was prudent to share initial findings with the superiors of those involved in the investigation?
What I can say is that it is normal in the course of an investigation for our investigators to share information with management so that they may take administrative measures that they feel are required pending the conclusion of the investigation.
Did you recommend that the report be shared with the deputy heads of Health Canada and the CRA?
I did.
You did. So when did you become aware of the suspensions of Mr. McDonald and Mr. Utano?
I became aware when the matter became public through the Globe and Mail, I believe it was.
Again, I'll ask, do you think it is appropriate to suspend employees without pay when you have only completed an initial statement of fact?
I can't speak to the appropriateness of the decisions taken by other departments. Mr. Utano and Mr. McDonald are not employees of the CBSA. I can't make any assessments relating to their employment. What I can say, and I think it's important for the committee to understand, is that it is normal in the course of an investigation to ensure that mitigating measures are put in place when there are potential risks. So that is something that is in our processes, and it is why we share information to management during the course of the investigation.
So how do you square that with the systematic approach of ensuring that all evidence is properly gathered and considered prior to final conclusions if, in fact, employees have been suspended without pay before a thorough investigation has been conducted?
So management may take any number of administrative measures pending the conclusion of investigation. I can speak generally, for example, if we're conducting an investigation indicating an employee may be disclosing information inappropriately, management may choose to remove their accesses to sensitive systems. So this is normal in the course of an investigation.
So were McDonald and Utano allowed to respond before their suspension?
That decision was taken by their respective departments. I can't speak to that.
Okay, thank you. We have heard contradictory testimony from President O'Gorman as to when the investigation began. Can you provide some clarity for us? Did it start in November of 2022 or January of 2023?
We started the investigation as soon as we received the allegations from Bottler AI in November of 2022.
In November of 2022. Okay, so it took you nearly a year to provide an initial statement of fact to the president of the CBSA, which happened shortly after McDonald and Utano gave testimony critical of President O'Gorman before this committee. And so I would just say that it seems odd that there was a sudden breakthrough in the case against these individuals right after they were critical of some of the actions taken and the testimony before committee. I also want to note that you mentioned in your opening statement that you provide management with reports of your findings. Does this include providing initial statements of fact?
We provide information to management as it comes up during the investigation. Usually it is not in a formal format. This was a different case as they were not employees of the CBSA.
Okay, so was President O'Gorman a part of the management team that you provided reports to?
She did receive a copy of the preliminary statements of facts, yes.
So then she had direct access to the investigation of former employees who publicly criticized her. I'm wondering, again, if you can provide us with your opinion on whether or not this does not seem like it compromises the integrity of the investigation. Does it at least not concern you that someone with in her position.
You'll have to wrap up, Mrs. Block, please.
Thank you. That has, I think, implied guilt before a final investigation, holds a position in regards to the power to investigate.
So, Mr. Chair, I can assure this committee that none of the actions taken in the course of the investigation were as a result of any evidence heard before this committee. Our investigation is proceeding in parallel with the work of the committee, but not as a result of anything that you've heard.
Thank you, Mr. Fleur. Mr. Shawari, please.
Thank you, Mr. Chair. Welcome, Mr. Lafleur. Mr. Lafleur, you've been called as a witness under the study of ArriveCan application. So for Canadians who are watching today, I'm going to ask some pointed questions, and then hopefully we could get into more in-depth conversation around the investigation that's going on. Are you conducting any investigation internal as it relates to the development of the application ArriveCan?
ArriveCan as an application is not something that we're investigating.
Okay.
We're investigating procurement matters around.
Okay. Are you investigating anything around procurement of any direct or indirect activities, whether it's procurement, whether it's a complaint, whether it's people's, as it relates to the application ArriveCan?
Some of the allegations that we are investigating do touch on contracts that were used for ArriveCan.
Okay, thank you. So, in your testimony, you talked about that you cannot, and I quote, therefore limited in what I can be able to share about the process. What I can speak about is our investigation process and investigation in general terms. So, can you tell us about your investigation process? I come from a management consulting background. We usually look at it. We look at the process. We look at the timeline. We look at the outcome. We have. Can you share with us the steps in this process, some of the outcome that anticipated, and the timing of these outcomes, and who you share these documents with, or you are allowed to share these findings at the preliminary stages with?
So generally speaking, when we receive allegations of employee misconduct, we initiate a preliminary review. The point of that preliminary review is to see if there's any evidence to substantiate whether something occurred or not. If we have evidence to substantiate, we would move forward to a formal phase of the investigation. If there's no evidence to support the allegations, we would close the file. If there's exculpatory evidence at that point, we would, of course, not move forward with an investigation. We try to do that preliminary phase within 45 business days. Of course, depending on the case, that may go longer, may be shorter. Once we have made a decision to move to a formal phase of the investigation, we determine the allegations that the employees would have to respond to, and those are detailed in relation to the CBSA Code of Conduct. The respondents in the investigation are then notified of the investigation of these allegations. We then proceed to witness interviews, to interviewing the respondents, before finally, once all the evidence have been gathered, drafting an investigation report with our conclusions. That report then is shared with CBSA senior management, and they are responsible for addressing any founded allegations of misconduct.
Thank you. So, are you in a position to be able to share with us whether you have completed the preliminary review?
With relation
as it relates to the investigation that you're doing?
Yes.
Because it looks like it's a two-stage, and if there seems to be some evidence within the preliminary review and within the first 45 minutes, then you proceed to the second stage, which you call the formal phase. Okay, so there seems to be that first phase is completed. It was a determination that it necessitates moving into a formal phase. You have already moved into the formal phase. Can you share with us where in the process that you identified from a formal process of allegation, and then meeting and conducting interviews, and then meeting with witnesses and all of those. Are you in a position to be able to share with us where you are in that process?
So we did complete the preliminary review. We have notified the respondents of the allegations against them, and we are proceeding with witness interviews at this time.
Okay, so you're in the process of doing the witness interviews?
That's correct.
And so is it fair to assume that given the fact that you have moved into a formal phase, you found evidence that you needed to be able to further explore?
As I've stated before, that is part of the process. Before moving to a formal phase of the investigation, we have to have some level of assurance that the allegations may have occurred.
Okay. Can you give us a sense? You're very clear on the 45 days in the preliminary review. Is there any timeline established for the formal phase?
So, depending on the complexity of the investigation, we aim to complete a formal investigation between 60 and 120 business days. Of course, when we're dealing with more complex files or files that involve potential criminality, those timelines can extend significantly.
Okay. So established timelines 60 to 120. If there is any criminality, potential criminality, then there is no timelines for it.
That's right.
Okay. I only got about 10 seconds. Is there any date established by when you're going to publish your report?
No, we'll be done when we're done our work.
Okay. Thank you very much.
Mrs. Vignola, please, for 6.
Merci beaucoup, Monsieur le Président.
Thank you very much, Chair, and thank you, Mr. Lafleur, for coming today. Recently, in the papers, we've read that some officials might have deleted some of their emails, and I'd like to know if that might have something to do with some hot topics these days. I'd like to know if you have seen in the past emails about a sensitive topic being deleted. Intentionally, I would say no. Now, in terms of email management, when we're talking about procurement, not just for, say, hot topics, but let's say there's a procurement process involved, is there any kind of email management process? I'm not an expert in contracts. However, as managers, we are responsible for ensuring that all decisions are documented. Thank you. So when this happens, when these are documented, is that consistent within all departments? So is the process consistent, or does each department have their own way of documenting decisions? I'm sorry that I can't give you that level of detail about this. Here at the committee, we heard from a whistleblower, and there was a process of investigation, and it appeared that people were protecting each other. So, with all due respect, when there are some very serious cases, such as the one that we are currently considering, would it be more efficient for the CBSA to investigate internally, or would it be better or more efficient for someone from the outside to investigate? Well, I would say that my role is to fulfill that role of an independent investigator, so I don't work for management as such. And this is how I explain it to my team. We are not working for them when we are conducting investigations. Now, if there were a fully independent function, yes, that could provide a certain level of assurance. But I would say that we're independent in our approach. When your investigation is finished, do your recommendations have to be, are they mandatory in terms of their implementation? Does something happen? Are those at fault, say, penalized or sanctioned? What happens after the completion of your report? Well, just a point of clarification. We only make recommendations in our report. So we outline the facts regarding the issues, and we reach our findings. We decide whether or not the allegations are substantiated, and that report is provided to management, and then it is up to them to decide whether any disciplinary steps will be taken. So there might be a verbal warning, there might be a suspension, there are a number of steps that can be taken. So you reach your conclusions, you decide whether or not there was fault, and then management decides what to do. But when members of management are involved, is it still management that has to decide what actions will be taken? And do you think that there may be a risk of just rapping them on the knuckles and asking them to please not do this again because their reputation is involved? Well, when there is an investigation into, say, senior management, then the report goes to a higher level, higher than the agency. And it is up to them to make decisions, and they are responsible for their decisions. So your role then is not to do a follow-up on what was actually done based on the report. So you'd simply table the report. I see. Now, Parliament Hill could also be called the Hill of Rumors. And let's say that parliamentarians have access to documents that aren't necessarily public. And let's say there's a rumor circulating about the content of those documents. Would any of those kinds of things, when there was an investigation, would any of that be included? Would you include those, what is being said? You mean in terms of how members are acting or what they're saying? No. My role is to investigate people within the agency. Thank you.
Thank you very much, Mr. Chair, and thank you, Mr. Lafleur, for being here with us and answering our questions to the best of your ability. And apologies to the committee if I'm a little slower than usual. The airplane I was on last night from Toronto suffered a cracked windshield in the air, and so it resulted in a very late night, early morning. Better safe than sorry, though. Certainly don't regret turning back when something like that happens. I thought I'd start my questions around potential criminality. And, I understand there's also an RCMP investigation that is ongoing. But in your work, Mr. Lafleur, if you came across instances of fraud or other criminality over the course of your investigation, could you go over what steps you would take if indeed you came across such examples?
Yeah. So the Policy on Government Securities Directive on Security Management, paragraph 4.1.7, requires us to report any suspicions of criminality to law enforcement of jurisdiction. So when that does occur, we would typically first reach out to the RCMP, have a preliminary discussion to confirm whether our understanding of what occurred may be criminality. We're of course, we're not law enforcement, but we do have a responsibility to report that when we see it.
I note, and we had the ombudsperson at our last meeting, and I note in the ombudsperson's response to, in the CBSA's response to the ombudsperson's recommendations, CBSA states, the CBSA is strengthening processes and controls related to procurement planning, contract administration, corporate culture, and proactive monitoring to reduce the risk of fraud. It seems from that sentence like they feel that there is some risk of fraud that has become evident through the course of these investigations and conversations. Could you talk a little bit about what kind of instances would constitute fraud in the context of the allegations that are being made in this investigation?
So I can't speak to any specifics of the allegation, but what I can say is that anytime there is an exchange of money between the government and other parties, there is a potential risk of fraud. So people may want to circumvent internal controls to try to get something out of the system. Procurement is one area, finance is another where that may occur.
So in the context of procurement, could you provide like a very generic example of something that would clearly constitute fraud?
I can. So there have been numerous, sadly, cases in the past around false invoicing, either completely false businesses invoicing to the government and maybe an employee circumventing internal controls to sign both sides of a transaction. That would be clear fraud. From a vendor's perspective, submitting fraudulent documents would be could be considered fraud. There's any number of scenarios.
And is looking for instances of fraud or other criminality within the specific scope of your investigation?
It's within scope of my duties. I have another function within my team that aims to identify potential fraud, corruption, misuse using the agency's data through proactive data analytics. As we get into a file like this and we see evidence of potential fraud, we would report that to law enforcement.
Shifting gears a little bit, I know Mr. Utano and Mr. McDonald came to committee at a previous meeting. I wasn't at that meeting, but I'm familiar with what happened, and they brought a number of documents. You're familiar with these, I assume. Were those authorized and provided by the CBSA?
I'm not familiar with the documents that they would have provided to committee.
Okay. Moving on to the issue of security clearance, one of the issues at play here is the fact that GC Strategies, which had participated in the procurement process, did not have the document safeguarding capability that was stated as a requirement of the procurement. Could you describe document safeguarding requirements for sensitive procurements like the ArriveCan contracts?
I can speak generally. Again, that's not my area of expertise, but I have some exposure to it as a security practitioner. So when we're talking about document safeguarding, it means that the vendor may be required to hold protected information within their physical premises or within their IT systems, which would be different than if they were working solely within CBSA space, where they may have access to systems of ours. But when they control it, they need to have measures in place to protect it.
And what's the risk of misclassifying document safeguarding capability requirements in a procurement process?
In what regard? Sorry.
Well, if a company that is participating in the procurement does not have the stated document safeguarding capabilities and is given the work anyway, what is the risk at play?
Obviously, there's a risk of potential disclosure of that information if it's not kept protected. Traditionally, we're talking about like certified filing cabinets, things like that. More modern times means encryption on their systems if they're going to be holding protected information. So obviously that's
Gentlemen, thanks very much. Mr. Brock, please, for 5.
Thank you, Chair. Mr. Lafleur, with all due respect, your investigation in this matter is seriously flawed. You talk about your 15 years of experience working on hundreds of administrative investigations. You highlighted today in your opening statement that your key role is to ensure the integrity of the investigation, procedural fairness, and due process for those under investigation. And those under investigation have been targeted by you as Mr. Cameron McDonald and Mr. Antonio Utano. They're the only 2 individuals under investigation, and what you have done so far, sir, is done anything but to ensure procedural fairness. So much so that they've retained a lawyer and a lawyer has brought an action in the Superior Court of Justice, and you, sir, are named as a defendant, as well as the Attorney General of Canada and the CBSA and Aaron O'Gorman, seeking declaratory relief that their rights to participate in this process has been compromised by you. You're aware of that? Right. And sir, you don't have a legal degree, do you?
I do not.
No, and you don't understand the difference between a criminal standard of proof or a civil standard of proof, do you?
I do have some understanding of the difference.
Proof beyond a reasonable doubt on the criminal spectrum, beyond the bounds of probability on the civil spectrum. And you understand the difference between fact and allegation, don't you?
Of course.
Yet I've got access, sir, to your Project Helios preliminary statement of fact for both Cameron McDonald and Antonio Utano, and you interchange the concept of fact, which is a proven entity, and allegation. In fact, the title of the document, Project Helios, Preliminary Statement of Facts. That's misleading, and it's wrong, isn't it, sir? Because these are allegations.
So the report itself is a point-in-time document, right?
Sir? These are allegations. Allegations brought by Bottler AI. Yes or no?
There are allegations.
They're not a proven fact, are they?
They are not.
So I would suggest to you, you be much careful in the future as it relates to this investigation and other investigations, that you understand, sir, that the clear difference between an allegation and a fact, because you interchange this throughout your report. And the statement of fact and this preliminary statement of fact was ultimately sent on to the new two departments that Mr. McDonald and Mr. Utonio are employed by, right?
They were.
Yeah, and you expressed serious concerns, notwithstanding that nobody has been interviewed, that Mr. McDonald hasn't been interviewed, that Mr. Utano hasn't been interviewed, that Mindone hasn't been interviewed, that Aaron O'Gorman, the president of the CBSA, hasn't been interviewed. Former President John Osowski has not been interviewed. You've identified a number of key individuals you want to be interviewed, and none of them have provided you with an interview, have they?
To speak as to.
Well, I have the
preliminary
information right before me, sir. It's very clear that none of them have agreed to interview with you yet.
If I could add a point of clarification there, so the report was a point in time.
I don't care about
assessment
point
of
in
the
time.
evidence on December
This
19th.
this is affecting the lives
To order,
and the
Mr. Chair.
livelihood of Mr. McDonald and Mr. Utano.
So, just one moment, Mr. Brock.
Can I ask my colleague, Mr. Brock, allow the witness the same amount of time to respond?
No,
Because
it
I'd
is-
like to hear,
Right.
the line of question is very interesting. I'd just like to hear the response.
I appreciate both of you. Stop. I've stopped the clock, but we've established in this committee it is the members' time. So please continue, Mr. Brock.
You made conclusions that were so significant that you felt that these were proven facts of serious employee misconduct, so serious that you required the RCMP to investigate at least 2 criminal charges, fraud and bribery, and then later on in this report, you declare that there's absolutely no evidence of bribery, as outlined by Bottler AI in their allegations. You remember saying that? That to date, there is no evidence of bribery? Did you actually share that with the RCMP? I bet you didn't.
That we have no,
Yeah. Did you share that with the RCMP?
we have provided information to the RCMP.
Did you share the fact that you have no evidence to support the allegation of bribery with the RCMP? Yes or no? It's a simple question, Mr. Lafleur.
I disagree. It's a yes or no question. We have provided.
Answer the question, Mr. Lafleur. Did you advise the RCMP that you uncovered no evidence of bribery? Yes or no?
The RCMP has the evidence that we have collected.
I'm going to interrupt here. We are out of time, but a very straightforward question has been put to you. Could you please respond in a yes or no fashion, Mr. Lafleur?
As to whether I've specifically told the RCMP we have found no evidence of, I'm just seeking clarity on that.
Could you repeat the question, just a very quick
Certainly,
one?
for
and then
the
we have to go to
sixth
Mr.
time,
Souza.
I'll repeat the question very slowly and carefully for you, Mr. Lafleur.
And be polite about it.
I will be, Mr. Chair, thank you. Baller AI raised concerns regarding bribery involving Christian Firth and Cameron McDonald. You raised that as a significant concern in your preliminary statement of fact. Paragraph 50 of your report
Mr. Brock, the
indicates that there was no evidence to substantiate the allegation of fraud. My question is, did you share your opinion that this allegation of fraud was unsubstantiated to the RCMP, yes or no?
That's not what the report says.
Sorry?
With respect, that's not what I say in the
I can-
report.
I can read it out
I'm
to
going
you.
We have no
to interrupt.
evidence?
I think we're going to get back to this in the
Yep.
next round, and we will re-clarify. Mr. Souza, please go ahead.
Thank you for appearing here today. You know, it's infuriating that we have an ongoing investigation. You made clear that you're taking the steps necessary to provide for that investigation so you can have a proper outcome. Some are arguing that you may be withholding information during this process, but in fact, you are taking the necessary steps. What's appropriate to disclose now versus what you're going to come forward with at the end needs to be understood, and I presume the line of questioning is to that effect. However, I also recognize that some of the prosecution efforts that this committee seems to be playing throughout this process, and now they're defending the very individuals that they prosecuted in the past and have made assertions that they have actually been dealing inappropriately and have been dealing in a way that is of misconduct. They've made that assertions. They've actually claimed that others and those individuals themselves have been lying to this committee, and now they're putting you under the gun for the same issue, and yet you're the one doing the investigation. So I'm just trying to comprehend, notwithstanding the antics here, that we get to the truth. And that's what they seem to be wanting, but they're making allegations themselves. And now they're prosecuting those very individuals. Now they're coming back trying to protect those individuals who they themselves have accused of lying. And we're not accusing you of anything. Let's be clear. We want to make certain that the investigation takes its proper course and that the results and the outcome is best understood. And I'm having some difficulty trying to understand how, well, first I have to ask, is it common to use general contractors, then they subcontract? That's normal.
It is something that's allowed within procurement rules based on my understanding.
And those things come with contracts.
Correct.
And then they come before the government in terms of what is being proposed and what is understood and what is agreed to during those contracts, correct?
Part of the process.
So how do you investigate a situation when there are no contracts? There's no contracts with a general contractor. There's no contract with a subcontractor. So, and the allegations are engaged in those areas, but there's nothing of legal consequence. So how do you proceed to investigate something that doesn't actually have contracts?
So I can speak generally that what we investigate would be around whether the individuals with authority exercise their delegation appropriately, whether the processes were followed, whether the various procurement policies were respected.
So can you explain the difference between an internal investigation and something that the RCMP would conduct?
So our investigations are with respect to whether the code of conduct was followed by employees in the course of their duties. The RCMP would be responsible for investigating potential criminality.
And you, since out of your own accord, you've provided the RCMP with an indication of that, and you've given them and released information to them. Have you had any discussions subsequent to that with
Yes,
the RCMP?
we have engaged with the RCMP throughout the investigation to provide them information as per their lawful requests.
Is specific to Bottler's allegations,
That's
or-
correct.
and where there is no contracts.
There was no contract with Bottler.
Right. So some here are claiming that maybe you're withholding information from us. Is that true?
Not at all.
And the information that you have, you've given to the RCMP. And then they have but they haven't conducted an outcome. They haven't determined any guilt, right?
That's my understanding.
Have you determined any guilt?
No, our investigation is ongoing.
So what is there that you can explain to us that would give us comfort that there's some wrongdoing? At this point, you're investigating any possibility of that, correct?
We're investigating the possibility of that, and there have been extensive disclosures to this committee pursuant to your production orders. You have significant amount of evidence to look at as well.
Right. And as you can tell through this committee hearings, we've had a lot of discussions around the activities, not just of Butler, but any other possible allegations that could be done. And of course, the Ombudsman came back with a number of recommendations. Are you aware of those recommendations?
I am.
Did you participate or cooperate with the Ombudsman during that procedure?
Yes, so I have responsibility for security screening for the agency, so we provided information around security screening questions that they had.
And there were practices that were explained that I understand has been prevalent throughout decades, even under the previous government. Is that correct?
It is my understanding that some of the issues raised have been systemic in government for some.
I know that some members across have suggested that something has just happened, which is not the case in terms of providing for, especially during the case of the pandemic, a lot of contracts were initiated, but then they've subsequently used their services to do other functions. Is that correct? I think they call them swaps or bait and whatever they're called.
Bait and switch or something like that. I can't speak to those details.
Yeah, have you seen that occur in the past?
I haven't had that many procurement-related investigations, so I have not.
Okay. And do you foresee anything of negativity there, or is there something wrong that's happened? Or did the Ombudsman say that there was any wrongdoing or any misconduct?
I don't want to misspeak. I haven't fully reviewed the Ombudsman's report. I do note that they had concerns and that we've taken steps to address them.
Do you know what our response has been in respect to the Ombudsman's report? Are you aware of cooperation or recommendations put
Just
forward?
a brief answer, Mr. Fleur. We're past our time.
The committee, sorry?
Yeah, no. The CBSA.
I am aware that we've strengthened procurement practices.
Thank you very much. Mrs. Vignola, please, for 2.5.
Merci beaucoup.
Thank you. Mr. Lafleur, I've read several documents. In terms of Butler's allegations to the CBSA, include the word bribery, because I've read documents and I don't remember the word bribery being included in those allegations. I couldn't say I don't have the report in front of me, but I don't believe so. Well, I'll check again then, because I think I have a good memory, but you never know. Now, do the documents that were provided to the committee, are they included, rather, in your investigation? Because some documents, I believe, have been deleted. Let's say emails, for example. So is it possible that some emails or documents might have been deleted? Well, during our investigation, I have access to all information from the agency, including what we've received, yes. Now, what happens if emails have been deleted before you've had an opportunity to see them? What can you do in order to access those emails? Well, our investigations, our administrative investigations, we cannot necessarily go and seize computers, for example. So we are limited in what we can do. If we have a copy of an email, well, we'll have that copy on the same day, but the agency system, the government system, only gives you a period of 30 days in terms of backup. So the emails might still be there. And so it all depends on when the email would have been deleted. Well, do you have access to those backups? Yes. Thank you. Do I still have time?
Go ahead, Mr. Bachrach.
Merci. I'll pick up where my colleague just left off. This question of the deletion of emails, I think there are many questions swirling around this, and I understand there are aspects of this you probably can't speak to, but perhaps the question I'll ask is, over the course of your investigation, is there any correspondence that's either been referenced in ATIP requests or referenced in interviews with witnesses that you have not been able to obtain through the avenues that are available to you? You mentioned you can't seize computers, but I assume you would have access to the CBSA's servers and central repositories of correspondence. Is there any information that has been referenced, specifically correspondence, that's been referenced in ATIP requests or referenced in interviews with witnesses that you haven't been able to access?
The lack of documentation on the procurement files is something that has been noted, and I believe the procurement ombudsman speaks to that as well. But I have seen no evidence to date, again speaking generally, not about any specifics, of evidence being withheld from ATIP requests or being actively deleted to keep them from our investigation.
Okay, thanks for that. I think one of the lines of questioning that my colleague Mr. Brock has brought up relates to this preliminary statement of fact. I haven't seen that statement of fact. However, he made some pretty, I think some pretty colorful allegations about your own competency as an investigator. You referenced in your opening remarks the terms of reference under which your investigation is taking place, that there are procedures that are set out by CBSA for internal investigations. Does anyone sort of check your work as an investigator? Is there any way for us the committee to confirm whether or not indeed the preliminary statement of fact followed the protocols and procedures that are established by the agency? How does that process work?
So you can see the policy on government security, which is something that's open to anyone, and the requirements therein relating to the sharing of information when there have been concerns raised. We do engage in a yearly quality assurance process through a third party that comes in and looks at our work and gives us recommendations with regards to our investigations and in respect to policy. So that's something that we have systemically within.
That is our time. Thanks very much. Back to you, Mr. Brock, please.
Thank you, Chair. Paragraph 50, page 10 of the Statement of Fact report as it relates to Cameron McDonald is largely redacted. It starts unredacted as follows. It is important to note that the true motivation behind these actions are unclear, and that while the Butler AI complaint appears to indicate that Christian Firth solicited a bribe for Cameron McDonald Exhibit Number 10, there has been no evidence gathered to date in this regard. I'll take it by your non-response, sir, that you don't want to share the truth as to whether or not that important piece of your investigation was shared with the RCMP. Now, on the issue of deleting emails, Mindone, just to clarify, has never been the subject of this particular Project Helios investigation. Is that correct?
As was published.
He's not part of the investigation?
If I could answer. So
I'm asking you, is he part of the investigation or not?
On December 11th, I received allegations, as has been made public, relating to Mr. Doan.
Is he still subject of an investigation?
That review is ongoing.
That review of whether or not he's going to be the subject of an investigation is underway, so that's a possibility.
The review of the allegations we received.
So that's a possibility.
Correct.
Correct? Now, Mindone confirmed this, and through ATIPs delivered to CBSA has confirmed that Mindone has 4 years worth of highly relevant, sensitive emails between the years of 2018 to 2022, which not only captures the pandemic and the ArriveCam scandal, but as well as the Butler AI investigations, have just mysteriously been corrupted. He's not taking responsibility for deliberately deleting that. The approximate amount of those emails is roughly 7 gigabytes or 1,700 emails. You would agree with me, sir, that emails are supposed to be...
Sorry, Mr. Brock.
Sorry, point of order.
Yeah.
Mr. Bacharach, and I don't believe any of us has actually seen this statement of facts. Do you have a copy that you can share with us? Because we're looking for it. I don't think
I'll address that. I'm the only one on the committee that has a copy of it.
so. Can we
I
have it
think Mr.
distributed so
Brock
we can?
mentioned, no, I'll discuss it on Wednesday. I think Mr. Brock indicated he received the information from two of our witnesses who have received it.
So we're not allowed to see it.
I'll discuss it Wednesday. But I'm the only one with the copy of it, right? Myself and the clerk are the only people with the copy of it right now. But I'll address it.
But Mr. Brock got it from a witness?
Not from the committee and not from CBSA.
So how did Mr. Brock get it? It's a point of order. How is it that certain committee members are receiving it and not all committee members?
This is not a point of order, Mr. Souza. I've explained to you, he did not, I'm the only one in the committee that has a copy of it, myself and the clerk. No one else has received a committee from this
Mr. Brock
committee.
has a copy.
I'm sure Mr. Brock also has copies of ATIPs that have not sent to us. I have copies of ATIP that have not been sent to the committee. You have emails that have not been sent to the committee because they were sent to him separately. I think Mr. Brock at the very beginning of the meeting, if you were listening, indicated he received it from the witnesses, which I assume are Mr. McDonald and Mr. Utano, who have received a copy. So, yeah, I think it was discussed at the very beginning of the meeting. Mr. Brock, you're at 2 minutes and 10 seconds, so you have 2:50 left. Go ahead, please.
Thank you, Chair. Min Doan at the time was the vice president of the CBSA. You'd agree with me, sir, that deleting emails is an extremely serious offense.
It would be a breach of the code of conduct to willfully delete emails.
And it's incumbent on an IT professional, as Min Doan was, to protect work emails dealing with official matters, correct?
It is part of our responsibilities. Yes.
And the level of seriousness increases dependent on the position that a public servant holds. In this case, a low-level administrative data entry individual is vastly different in terms of the serious scale than the vice president of the CBSA when you reference deleting emails. Would you agree with that? When was the president, Aaron O'Gorman, informed about Mr. Doan's deleted emails?
We have not concluded that there were any deleted emails.
When was she informed, sir?
She was informed of the allegations when I received them.
Of the deleted emails?
The allegations as I received them.
When was it?
December 11th is when I received them. I can't recall exactly which date I would have.
When was the Auditor General notified of 4 years' worth of deleted relevant emails?
Again, one point of clarification, I have no evidence that there has been deletion at this point. We are looking into the matter.
Can you answer the question, Mr. Lafleur? When was the Auditor General notified of 4 years' worth of a Vice President's deleted email account? When was she notified, and by whom?
So I can say that during our various engagements with the Office of the Auditor General, we have provided them with all of the information that we had available.
Did you inform the Auditor General yourself, sir, or someone under your control that the Auditor General received evidence of 4 years' worth of deleted emails by Min Doan, Vice President? Yes or no?
Again, I'm not sure what you're referencing. I did meet with the OAG.
Chair, can we get some clarity, please? My questions are very direct.
Yeah, Mr.
And this
Lafleur,
witness has a
we
hard
do ask
time.
you just respond and just a direct answer, please. If it's a yes or no, please a direct yes or no, but otherwise a direct answer so we can move on.
Did you notify the Auditor General of 4 years' worth of deleted emails?
I notified the Auditor General that I had received allegations to that.
And when did you notify her?
In December, after I received the allegations.
December of 23?
23.
Okay. Was the Treasury Board Secretariat informed?
No.
Did you inform the RCMP of potentially 4 years' worth of highly confidential, relevant emails?
We are required to report potential criminality. I have no evidence of that at this time.
Thank you, Mr.
Wow. No evidence
Yeah, that
of
is-
potentially
that is our time, Mr.
deliberately
Brock.
deleting emails, and that is not criminality to you?
Mr. Brock, that is our time.
Wow.
Mr. Baines, please, go ahead.
Thank you, Mr. Chair, and thank you, Mr. Lafleur, for joining us today.
Ask if it's confidential.
So the statement of fact, which we've been talking about in the last few line of questioning here, is that confidential?
It is.
So the witness sharing it with a member opposite, is that some type of breach of any sort?
I'm not aware of any sharing that would have occurred.
Well, Mr. Chair here had confirmed that Mr. Brock received it from a witness. So would that be a breach of any sort in this investigation? Is this in a way undermining the investigation that's ongoing? Are they supposed to be talking about this?
I would say it depends on who it came from. Obviously, I would have concerns if that had come from a member of my investigation team.
Well, Mr. Chair here just confirmed that it came from a witness, that Mr. Brock directly received it from one of the witnesses. Which witness, we don't know.
If it was to somebody who it was provided and it may be considered their personal information, they are free to share it as they see fit.
Okay, so it's there, but it's confidential. Then you just said it's confidential. You can't share it, but a witness can share it?
If it's about them, they
Right, okay.
could share it.
So in the scope of your duties, are you concerned? You mentioned that there's been some things, some systemic issues with respect to contracts and documentation and these sorts of things. Are you concerned within your investigation now and you're uncovering things, you're finding things, if there's widespread corruption in your organization?
I've seen no indication of widespread corruption. We provided information to the president in the fall of 2023, after which she took a number of measures to strengthen procurement within the CBSA. I'm comfortable that those measures are serving their purpose.
So this incident specifically that you're seeing, is this like the first of its kind that sort of, in a way, like we've been extremely confused. It's been like a tangled web and there's still a lot of clarity that needs to come forward here. So is this an isolated incident in your time that you've seen?
It is the first time that I see a file of this complexity and seriousness relating to procurement, yes.
Okay, so if you're looking at like the Treasury Board guidelines for discipline, like in which circumstances might public servants' presence at work undermine or impede an investigation, as described in the Treasury Board's guidelines?
So I can speak to the Treasury Board standard on security screening, which outlines when an employee may need to be suspended. And speaking generally, it's when they would represent a potential security risk to the organization, to people, information, or assets, or to the conduct of the investigation. So again, speaking generally, if someone is under investigation in the workplace and still has access to witnesses, they may try to influence them, so that would be a concern. So they may be removed from the workplace to protect the integrity of the investigation.
So, seeing how Mr. McDonald and Mr. Utano are suspended, like, is this one of the risks that you thought that or CBSA is seeing, that they may have access to information and that's why they've been limited to that access and been suspended?
So Mr. McDonald and Mr. Utano are not employees of the CBSA, so I can't speak to the decision to remove them from the workplace. I can say that generally speaking, it is normal in the course of an investigation for management to assess whether there is a need to mitigate potential risk pending the conclusion of the investigation. In the case where they have identified a potential risk, they have the responsibility to ensure that temporary measures are put in place to protect the organization, to protect the workplace, until an investigation is completed and final decisions can be taken.
There's been, we've received some feedback from some of the witnesses that have appeared here before, and they've declared that there's some challenges with their health, that they're unable to come back. Has this limited your investigation in any way?
I can't speak to any discussions that we may have had with potential witnesses. I will say that I have great sympathy for the stress that anyone involved in an investigation, whether it be a witness or someone who is under investigation, may face, particularly with the level of public scrutiny that this file has had. I can appreciate how that is
Thank you,
extremely stressful.
gentlemen. Mr. Genuis, please, for 5.
Thank you, Chair. Mr. Lafleur, you're tasked with providing an investigation internally into what happened with ArriveCan. I am interested in what seems to be the difference in the level of interest you're applying to allegations against different individuals. Your preliminary work at least seems to suggest a profound interest in allegations against Mr. McDonald and Mr. Utano, and a surprising lack of interest against Mr. Doan. I note that Mr. Doan faces serious allegations related to the deletion of documents, and that no provisional action seems to have been taken against him, while Mr. McDonald and Mr. Utano have been suspended without pay. Could you provide the committee with any explanation as to your relative much greater attention to allegations against Mr. McDonald and Mr. Utano compared to allegations against Mr. Doan?
I would disagree that there's been an undue attention given to one over the other. We received allegations from Bottler AI in November of 2022. It would be expected for that investigation to have proceeded much further than new allegations that I received in December of 2023.
Okay, so your explanation is that you received the allegations against Mr. McDonald and Mr. Utano earlier, yet Mr. Utano and Mr. McDonald received a letter notifying them of the investigations against the allegations against them on November 27th of this year. That was, again, suspiciously 20 days after their damning testimony before this committee. How are we to understand the fact that allegedly your investigation had been going on for a year, and yet they received a letter notifying them of the investigation in November of this year?
If I can have a minute perhaps to explain that timeline. So we did initiate an investigation in November 2022, considering the potential criminality. When we have interactions with police, we do respect the integrity of their investigation. And in this case, we could not proceed with interviews or with notifying the individuals under investigation with respect to the RCMP investigation. So since we're talking about the same witnesses, the same evidence, we were limited in how we can proceed without negatively impact the RCMP investigation. That scenario changed when the Globe and Mail issued their report on October 4th of 2023, and holding back on our investigation became a moot point at that point, which is why.
And yet it was still after their testimony on November 7th. Like this, even what you just said doesn't make any sense from a timeline perspective, because the Globe story that you referenced was the beginning of October, and yet it was only after their testimony before this committee that they subsequently heard from you that they were under investigation. This whole thing is just bizarre in terms of the investigation, because you said investigation started a year ago, but somehow it was only within a couple weeks of them coming before this committee to give damning negative testimony about the government in response to questions they were asked, that they were told that they were under investigation. They were subsequently suspended without pay. Meanwhile, we have these very serious allegations against Min Doan that involve hiding information, deleting emails, and as far as I know, there's been no action taken against him. The clearest difference to me between Mr. Doan and Mr. McDonald and Utano is that Mr. McDonald and Utano gave very blunt, critical testimony, whereas Mr. Doan obfuscated, prevaricated, didn't answer questions, and gave every indication of trying to defend the party line. And I get the same impression here, that you who are subject to the leadership of CBSA are looking at one set of allegations against one set of individuals and not against others. Maybe the best way to go from that is to ask you, sir, about your own reporting chain of command. You have characterized your investigation as independent, but you're not independent, are you? You're part of the department. You're subject to the authority of the department, and you're movable, reassignable at any time. Is that correct?
Of course, I do not have the independence of the OAG or the procurement ombudsman, for example. but I do have the space and time to conduct my work independently within the agency.
Okay, you would like us to believe that you have space and time to act independently, but substantively in terms of your role, you are not independent. There are no independent attributes about your role. And you even told us that you're informally providing information to your superiors at CBSA on an ongoing basis.
To wrap up,
You are
please.
not an independent investigator. You are their investigator, subject to the authority structure within CBSA. Do you think that compromises the integrity of your investigation?
Very, very brief answer, please.
It is normal for departments to investigate matters that occurred within their departments.
Thank you very much. Mr. Kuzmirchuk, please.
Mr. Chair. Thank you, Mr. Lafleur, for being here with us here today and bringing your testimony. Over the course of the last number of months, we heard testimony that there's allegations that CVs were being inflated in order to win contracts. So bona fides were being inflated to win contracts. Is that enough grounds, in your experience, to proceed from a preliminary review to a formal investigation? Just on those grounds. If someone is caught inflating CVs to win contracts, is that typically enough to move from a preliminary report to a formal report?
So maybe one point of clarification, if I could. I wouldn't be responsible for investigating the actions of vendors, only of employees of the CBSA.
Fair enough. Okay, fair enough. It's a good answer. Wanted to ask you, how many procurement-related cases have you investigated? You've been doing this for 15 years. Are the vast majority of the cases related to procurement? Is a small subsection related to procurement? Just curious if you can speak to that.
It's a very small subsection.
It's a very small subsection. Okay. In your experience, this case that you're examining right now, how normal is it? How out of the ordinary is it? If you can maybe speak to that a little bit. Provide us a little bit of context in terms of what we're looking at here.
So my presence before committee today is highly abnormal. As someone who is responsible for conducting an administrative investigation that is ongoing, being asked to speak publicly is not normal, and it is a challenge. I do have responsibility to ensure the integrity of the process and procedural fairness for the individuals under investigation. And I also have a responsibility to ensure that our investigation ultimately is able, if there is wrongdoing identified, to lead to accountability. So while I have great respect for the work of this committee, it is difficult to answer some of the questions relating to those very pointed points.
I know you can't speak specifically to this case. I understand that, but I just wanted to ask the specifics of this case. Are there things that you have not seen in your experience in your 15 years that you've seen in this particular case that you're investigating?
Absolutely.
Okay. Can you tell us when the preliminary review was completed?
So the preliminary review, it happened relatively quick. So I would say by December of 2022, we had evidence that at least some of the allegations appeared to be substantiated, and we would have been in a position to proceed formally with the investigation at that time, were it not for the ongoing criminal investigation.
How much time did it take before moving from the preliminary to the formal, roughly speaking? What are we talking? Is it a matter of days, weeks that you make the switch to a
Generally
formal?
speaking, it can take up to 7 weeks. We give ourselves 45 business days
Okay. To switch to the formal.
to move to formal.
Who makes that decision? Who makes that decision? Is that your decision, or does someone make that decision for you and say, okay, we want you to move into a formal?
In the normal course of an investigation, it would be the investigator and the responsible manager that would make those decisions.
Okay, so in that case, it's yourself with management makes that decision together?
My management team,
Your management team?
yes.
Okay. Okay, gotcha. I actually have a question for the chair, if that's okay. Thank you, Michelle. I just wanted to know, Mr. Chair, when did you become aware that a member of this committee had the preliminary statement of fact?
Pretty much today, I understand such details. But I'm
And
not sure if he has the full. I'm going to stop. Well, I'm not sure if he's got the full report. I was intending to discuss the release of the report because there are some issues around that we have to decide as a committee. I was going to do it Wednesday, but I think we're going to move that up in camera right after we finish our committee business.
As you can understand my concerns here, it seems that there's certain members, and I'm not sure if the other members of the other conservative MPs have access to this information.
This is very often, though. There are certain MPs that have ATIPs, that have other reports that others do not have. But I think that's up to the members to discuss that with or do their research on that. But
no, just as a matter of process, I would expect that the moment members of this committee, and especially the chair, have information, asymmetrical information, that is distributed, or that is at least that we are made aware of the fact that that information is now out there. I think that is really important to the work of this committee.
Yeah, it's fine. Continue your point of order, and that is your time. Then we'll discuss the actual distribution of it.
Yes,
today.
Mr. Chair, I just think a point is getting confused here. Obviously, if in his capacity as chair, the chair has sent information for the committee, he should be distributing that in a symmetrical way to all or to none. However, if members, clearly all of us have different levels of information that we get from different conversations we have. That's extremely normal. Members of the government presumably have conversations with government ministers, government political staff, and know things that we don't know, and we have conversations that they're not part of, and so everybody knows things that somebody else doesn't know. The question is around the distribution of information from the committee.
Right, and I appreciate the
those
point
things
of
are being
order,
conflated.
but to be clear, I've got one copy here, and the clerk has a copy. And Mr. Fleur and I sure, dozen people at CBSA, I'm sure Ms. O'Gorman, and the witnesses lawyer. And however, many people have been distributed, but we'll continue the conversation about distribution.
Sure. No, thank you, Mr. Chair. And I just wanted to make sure that the moment that the clerk and the chair is made aware that the information is out there, something as important as this.
I would disagree, and I'll end it there because I'm aware that certain people have ATIPs that have been shared with them that haven't been shared with anyone else, but that's because, and it's kind of, no, but it's something that if someone's done the research and received information that you have not, that's coming upon.
What I'm saying, Mr. Chair, is that the moment that yourself as the chair or the clerk is made aware that there's information that is confidential, that is being shared, I think it's important that is shared with the rest of the committee.
I would disagree, but the distribution of this, we will discuss among ourselves how to be distributed, and I'll explain a bit further why, and there are kind of rules around it.
Sure.
But I will disagree with you about that.
Do I have time for Mr. Lafleur?
You've got like 3 seconds, so why don't we just move on to Ms. Vignola, because I'm going to try and get through the round so we can get to our committee business. Go ahead, Mrs. Vignola.
Merci.
Thank you. Mr. Lafleur, during your investigation, were you able to hear everything that had been said here, and were you able to check the testimony? I heard testimony, but not necessarily to check anything in that testimony. Thank you. Was it useful to your investigation? Yes. Now, with respect to this Helios project, if a confidential document ends up being sent to someone from somewhere, we don't know from who, could that document be discussed publicly? So what I'm saying is, can anything being discussed here interfere with your investigation? Well, I would say that my role is to ensure the integrity of the investigation, regardless of what happens around this table. But if you're disclosing, if someone is disclosing a confidential document, does that put any extra pressure on that investigation, or does it call into question the integrity of the investigation? Well, I would say in terms of the public interest is something that we need to manage. Now, if the document was requested by the committee, I understand that you'll be discussing all this. But we want some things to be kept confidential for the integrity of the investigation. Well, I think it's quite extraordinary that we're spending so much time on ArriveCan that costs so much money, but so much less on the sponsorship scandal. And we ended up getting what we needed in terms of information, but it took a very long time. Regardless, I thank you very much for providing the information that you were able to provide us with today.
I apologize. I had someone speak in my ear. Was there a question toward me, or are you done, Mrs. Vignola?
Ms. Vignola has again granted her extra time to me, which,
well, you have, you have about an extra 5 seconds.
Wellspring of generosity came from, but I appreciate it.
I'm always nice.
Always nice, yes. So, Mr. Chair, this is it's turned into quite a twisted tale here, and I'm trying to follow all of these twists and turns as someone who joined the committee partway through this study. There's a lot of complexity here. We have this preliminary statement of fact that sounds like it's very interesting. Some members of the committee have it, others don't.
Anyways, go ahead, it's your time.
Well, it seems to me that some members of the committee had it because they were reading from it and they said they had it. So, we're in this strange position where Mr. Lafleur can't give it to us. The chair has it. We're going to discuss apparently whether we can see it. It seems to me that it would have been helpful for this line of questioning today for all members of the committee to have it so that together, because we're all seeking accountability here, together we could ask questions of Mr. Lafleur, who's the author of the preliminary statement of fact. It also seems like having that out in the open in some ways puts additional pressure on the investigation, and granted, but we're already down that path now. And one of the interesting things here is that we have these two civil servants, and I wasn't here for their original testimony, but I understand that they were subject to some fairly strong lines of questioning and allegations from my Conservative colleagues at previous meetings. Now the Conservatives seem to be running interference for these same civil servants who appear to be giving them confidential information so that they can ask certain questions at a committee where not all members are privy to that information. So it creates a very odd dynamic, and it seems to me like the best way to clear the air is to simply have the preliminary statement of fact on the table, to invite Mr. Lafleur back so that we can ask him additional questions about the content of that document, because frankly, a bunch of us are playing with one hand behind our back because for whatever reason, certain witnesses felt that giving those documents to some members of the committee and not others was going to be to their advantage. And, we're in a situation where obviously these allegations are extremely serious. If the allegations that have been made in the Bottler report turn out to indeed be true, this indicates that there is serious wrongdoing amongst civil servants working on the ArriveCan procurement. And that's something all Canadians should be concerned about. So, Mr. Chair, if you'll grant it, I will make a motion that the committee be provided with a preliminary statement of fact immediately.
Maybe just a quick point of order.
You will burn out your time to discuss your motion to begin with. The second, I would ask you that we wait. Again, I will discuss it, how we will proceed with it in camera, or we can do it publicly if you wish. It's up to you. But
Publicly.
Sure, we'll do it.
Sorry, Chair, just a point of order. I don't know if the motion would be in order because I proposed exactly the same motion and the committee adopted that motion. I think early last week, and it had a 3-week deadline. So I gather we're going to have a discussion about how to dispose of these documents.
It's a duplicate of Mr. Genoves's motion from 3 weeks ago.
Can I respond, Mr. Chair?
No.
I think
It is.
The committee
Gentlemen,
has
okay,
ordered
let me
documents.
interrupt. I have the floor here. Mr. Genuis, I have the floor. Yeah. Mr. Genuis is right. It was, basically you're asking for a duplication of a motion that's already been received. We'll discuss it right now, actually, then, and we may lose the time for your motion, but we're going to discuss it right now, committee. The request came in from Mr. Genuis for these documents. We agreed. The committee agreed to pass a motion to have the documents provided. CBSA wrote to me saying we will provide one copy only, and it'll be under lockup. No one will see it. One copy and wasn't translated. We wrote back saying, no, that's not the motion. You will provide it. She wanted it held in private for sensitivity. We wrote back saying, please provide it. So I will take a look. I will read through it to see how sensitive it is, see if it actually is sensitive stuff. I've read through most of it with notes that I was going to discuss in camera, but we'll do it publicly. I was going to suggest that we distribute it only to the members itself, not to the wider 48 people generally on our email list that it is provided. I spoke to the clerk today before the meeting on how we do that. We just need a motion. My suggestion was going to be to propose we share it translated, but only to the members itself, not to our staff, not to the usual 47 people on the list. That was going to be my proposal on Wednesday. It seems to be moved up. If you wish to discuss it now, that would be my suggestion, that we share it only with the members. Mr. Souza?
So, Mr. Chair, the issue that we're having here is obviously Mr. Brock, who's not a regular on this committee, has had access to this statement of fact. You're aware that he had it, and you have it, and yet you
Okay, let
didn't.
me interrupt. I was aware he had it when he spoke about it, but I have to question whether this is the first. I'm going to say it to all of you, and I'm very kind of stunned. It's almost like the first committee, all of you. The amount of time all of us receive reports or emails or ATIPs to us that don't go to everyone.
Mr. Chair, my question
And
is.
yet, also now someone has one and it has to be shared?
No. Listen, I just want to understand, Mr. Chair. I apologize. I'm not as astute when it comes to these procedures, but it seems to me that if you're aware that Mr. Brock has a statement of fact, you have it and the clerk has it, and you decided not to then share with the rest of us, knowing that
That's not the case, Mr. Susan. This will be the third time I've said it
So
to you.
when did
and
you
I'll
know
repeat
that he had
again.
it?
You asked that earlier, and about 15 minutes ago, when he stated at the opening that he received some information from the witnesses. The witnesses, I'm aware, and their lawyer, I am aware, have a copy of it. Mr. Lafleur and how many people, CBSA or CBSA, have it, I am not sure. But even if it was shared by the witnesses, or Mr. McDonald or Mr. Utano, that's their right. And that's their right to share it with anyone they want. But that does not mean that you have the right to see it or that anyone else.
No, but we're asking, Mr. Chair, I'm just trying to understand. I'm asking for the committee's right to have information shared when it's already in the hands of others, and knowing that it's in the hand of others, it could have been appropriate for us to suspend and then share that document. I guess that's all my point, so that we can all have seen
I
it.
will repeat, as I said earlier, before the meeting started, discussed this with the clerk. My opinion was to share it only with the members itself. I asked for procedure on how to do that. Before the meeting started, the clerk advised, do it as a motion. My intent was to do it in camera Wednesday, but now it's been pushed ahead. But if you wish, we can do a motion right now to share it just with the MPs, which is my thought, or with the broader mailing list, which is, as we generally share other issues, or we share with the MPs with the understanding it remains confidential, which is how we do on documents. But someone sharing something that is theirs to share with, they decided to share with you, that's their business, and that is your business. That does not mean has to be shared with everyone else until the committee decides. We were going to decide it Wednesday, as I discussed with the clerk at the beginning. And you can confirm that with her if you wish. But it seems to be pushed to right now.
Seems appropriate, and I just was concerned that somehow it's been held off, knowing that Mr. Brock had it.
I will
we should have.
repeat,
But
Mr. Souza,
but I'm
if you
just
wish to check with the clerk and reconfirm my discussion with her at the beginning, we will do so, Mr. Souza. But I'm getting a bit tired of your insinuations that perhaps some people are receiving the information inappropriately from the clerk or from myself. Mr. Brock.
We are wasting such valuable time with this important witness. Given the fact that we have more committee business to undertake, I am asking that we reserve our right to recall this witness. I think there are a lot of more questions that all members, and if the motion is passed in terms of release of documents, are going to have for this individual. Insofar as preparation of this particular meeting, every member exercises their own unique due diligence. So what I do in terms of preparation should not be the standard by which any other member should equate that to. I take this stuff very seriously, as I know my colleagues do. And there's an important point to make here. There is no proprietary interest in any witness. There is nothing preventing from any member of the Liberal bench from actually reaching out to Cameron McDonald on the telephone call or Mr. Utano and asking pointed questions, which is precisely what I did. I spent some time with both individuals gathering information. That information, I'm not under any legal obligation to share that with opposing members.
I agree. Colleagues, are we ready to make a decision and move on, or would you like to discuss it further Wednesday, or? Again, my proposal is to share it solely with the members of Parliament on this committee.
Chair, can we take a 2-minute recess? Thank you.
We'll suspend for 2 minutes, but please, 2 minutes maximum, guys.
Yes,
Go ahead.
request. Thank you for offering us to to verify. And again, this is nothing; it's just procedural. Can the clerk inform us as the time that that she received the statement of preliminary fact?
Probably
Date and time.
About a week ago. This is the letter that we were talking about last meeting, actually.
So specifically the document that you pointed to, that you've highlighted, when did the clerk, time and date, that received that big document that our colleague, Mr. Brock, has been referring to?
We're just looking it up.
Thank you.
We'll suspend for a moment, but I believe it was, I think probably January 30th or February 1. But we'll double check. just to me.
To the clerk,
Oh, no, went to the clerk. Clerk forwarded it to me.
and the clerk wasn't CC'd. Just the clerk?
Thursday, the 1st, as I said.
Okay. Got it.
Yeah. Mr. Kuzmierczak?
Mr. Chair, I have a serious issue with the fact, brilliant, Garnet, with the fact that the clerk had,
Disingenuous.
the clerk and the chair had this report, the statement of fact, in your possession last week, very early last week, knowing that the author of that report was coming before this committee today. And yet there was no indication, no communication from you to let us know that there was communication from the CBSA regarding this report. And it takes a second to sit at a computer to say, folks, I know we've got Mr. Lafleur testifying on Monday. Heads up, I've got a report in my possession, as does the clerk, that is pertinent to his appearance before this committee. It takes a split second. And I don't understand the logic of not sharing that information with this committee so that we can make an informed decision as a committee whether we want to defer or delay the appearance of Mr. Lafleur to give us the opportunity to decide whether we want to look at the statement and then even have an opportunity to look at the statement before the author, the investigator, comes before the committee. That I cannot understand your logic, Mr. Chair. I have a serious issue with that lack of communication with the members of this committee on such an important issue. And your explanation doesn't fly, Mr. Chair.
I guess we'll agree to disagree, Mr.
I
Kuzmierczak.
think it's more important than that. Moving forward, I think it's more important that this committee have the opportunity to have a say in how it conducts its business here. And pertinent, important information was withheld from this committee. And I think we ought to have had a chance.
Well, let me
to see that
respond. On
statement
January
in
29th, you received a letter about the report from President O'Gorman. If it was that important, as you've been stating, you could have simply, as you said, sent a simple email to me asking to have that distributed.
Mr. Chair, we depend on you because you received the information you shared with us over the break that you read through the report. Why were we not given the same privilege?
Mr. Kuzmierczak, every single one of you received a letter on the 29th from Ms. O'Gorman about the report. Certainly any one of you could have simply said at that time, hey, let's get the report out. You could have simply said on Wednesday, Mr. Genuis, Wednesday or Thursday or Friday, or Saturday, Sunday, or even this morning, knowing that we had Mr. Lafleur coming, hey, we want to see the report. But it's not like it was a big secret. We knew about the report. Mr. Sousa actually referenced this letter at our last meeting. So you certainly could have addressed it then if it was all important. Mr. Genuis, then Mr. Bachrach.
Yeah, Chair, just respectfully, we have Mr. Lafleur before us. I have more questions that I'm hoping to ask him. And we have this sort of silly process point from the government who, on the one hand, seems surprised that somebody might know something they don't know because of something they might have been sent directly. And secondly, they don't seem to appreciate sort of the legitimate exercise of chair's discretion at all. I've been on many committees, and it seems that the issue the chair has articulated is he has sought to get access to this information for the committee, and CBSA initially was trying to not send it or have it distributed at all, or require people to be in a locked room. So the chair has undertaken a negotiation process back and forth in order to get the committee access to this document. Let's remember, it was my motion to give us access to this document in the first place. When I initially put that motion forward, Liberal members said, oh, we don't know, we have to wait, we need to see it in both official languages. So then I put it on notice, had to bring it back. I think it was a week later, and that's when we got it approved. So, if the members of the government are so eager to get access to these documents, then they should have just approved my motion to request it. And we have people proposing that we request documents that we've already requested. So look, the chair's put forward a proposal to say he'd like to distribute this document to members. I think let's approve the sending of that document to the members. And I'd be happy to have Mr. Lafleur back. I have more questions to ask him. I don't know if I'll get to ask those questions today, but I do suspect that this may be the government just wanting to eat the time that would otherwise be spent asking questions of Mr. Lafleur. I'm ready to get back to work, and let's pass. Let's agree to allow the chair to distribute the document, and let's get back to work.
Mr. Backrack?
Mr. Chair, with regard to this line of conversation around when the chair knew what he knew, how it was communicated to the committee, how we ended up here without the statement of fact with Mr. Lafleur here, I don't think we're going to get anywhere in that conversation. There are things going on. There are strategies being employed. I'm reminded of that famous quote from Casablanca. I'm shocked to find that gambling is going on in here. It is what it is. We're not going to change what's already happened. We have to move forward. I think, given that some members of the committee are talking about the statement of fact and reading from it, it would be beneficial to have the whole thing in front of everybody. I have no way of knowing whether it compromises the investigation because I haven't seen it, but it would seem that putting out portions of it and not the statement in its entirety is not to the benefit of transparency and accountability. So I'll leave it at that. It sounds like we're going to have that conversation. Potentially, we'll have Mr. Lafleur back at a future date once we have the statement in front of us. We are running out of time in this meeting, and I had hoped to bring forward my motion. So if I may, Mr. Chair, I'll take this moment to thank Mr. Lafleur for his time with us today and to move my motion, which has been put on notice, that the committee undertake a study on the loss of postal service in Canada's rural and
Chair,
remote...
just a point of order. I was under the impression that we had a motion on the floor.
We're still discussing the motion to release this. Can I address a couple of things quickly?
Mr. Chair?
There was a motion about releasing the documents.
I made a motion and I withdrew it.
No.
But was there previously a motion made at this meeting that was being debated?
Yeah, about the
From whom?
the documents.
From whom?
Actually, well, I had put forward, and we were discussing whether we were going to release the documents or not.
Can we have the motion read back?
Yeah, tell you what, why don't we just? I think we'll get to yours, Taylor. Let me just.
No, it's like, well, now we have 10 minutes, Mr. Chair. Like the question
we'll have
is,
less if we continue.
you just said that there's a motion on the floor. I'm just asking you to read back the motion.
It was the motion to release the documents. You cannot. We cannot.
Who was the motion?
Take back your motion without without unanimous consent.
Mr. Chair, through you, could I ask the clerk what the motion is that we're debating currently? And who put it forward?
Going back with the chair, it was yourself, and then you said you withdrew it, but you can't withdraw without UC, and you do not seek the UC. So technically, we are on that motion. I think we could probably settle it really quickly and then get to your Canada Post motion, because I want to get to that today.
You ruled my motion out of order, Mr. Chair. I think if you check the record, you said that there's already a motion from Mr. Genuis that is duplicative.
So I apologize. We apologize. Thank you. You are correct there. I apologize. We cross lines here. Can I? Yeah. Oh, thank you. Megan, that's very kind of you. We do have time. We'll get to that, I promise. Can we just agree to hold on just 30 seconds, please, before we get to that? Are you want talking the Canada Post or?
No, I'm talking about the other issue.
Okay. Doesn't look like we will have the 30 seconds. Why don't we get to Mr. Bachrach's motion, because it is in, he has the floor, it is in order, but I hope we can get back to this to decide today about whether we're going to release it just to the MPs, as I suggest, or if you wish it to the larger audience or the larger email thing. But we're on Mr. Bachrach's motion, Mr. Sousa.
Thank you, Mr. Chair. Issues related to postal service fall squarely within the mandate of this committee. In the region I represent, which is a region made up of rural and remote communities, there are a lot of concerns about the loss and the sustainability of rural postal service, particularly rural post offices. And in a recent conversation with Canada Post, I became aware that the financial challenges of the corporation continue to worsen. I expect we'll be hearing from Canada Post at a future meeting, but I am gravely concerned about the future of postal delivery in rural and remote Canada. This is a lifeline for so many people. People order their medications through the post. Small businesses ship their products through the post. Many seniors who don't have access to technology rely on postal service for communication. And of course, in areas of our country that still lack broadband internet, postal service is vital for a wide range of government services. So I will move the motion that I have put on notice with a change of one word, which came from consultations with the chair. Okay, if we're going to be a stickler for procedure now, I will not change any of the words in my motion, but rather read it into the record, that the committee undertake a study on the sustainability of postal service in Canada's rural and remote communities, that a minimum of 12 hours of witness testimony be dedicated to the topic, that the committee invite the CEO of Canada Post, President of CPAA, and Minister of Public Services and Procurement, and that the committee produce a report and table it in the House. Thank you, Mr. Chair.
Thanks. Who can do your friendly amendment that you've just
I note, Mr. Chair, based on conversations prior to the meeting, that there are several amendments that members would like to make, and I'd be happy to consider those. I do feel that this is going to take more than the 10 minutes we have left in the meeting, and so hopefully we can consider this at our next public meeting and arrive at a motion that meets the needs of everyone around the table.
So perhaps someone can read that could possibly
sure, I'd be happy to speak to that. So in our conversation after the last meeting, you raised questions about the word sustainability, and I know that the word sustainability means different things to different people. What I'm getting at here is the long-term viability and sustaining of postal service in rural and remote Canada. And really, this study is on the loss of postal service. What we've seen over the years, particularly since the moratorium, I believe in 1994.
So we'll try and work that into any amendments. Then.
Okay, sure. What I was going to say is that we've seen a lot of post offices lost, despite there being a moratorium on the closure of post offices. And I'd like to get to that issue specifically. Thank you.
Ms. Block, then Mr. Sousa.
Yeah, and I would like to add to that amendment, if I may.
Excuse me.
Oh, Ms. Block, then Mr. Sousa.
Thank you very much, Mr. Chair, and I will be proposing an amendment to Mr. Bachrach's motion. I would propose that we replace the words "a minimum of 12 hours of witness testimony be dedicated to the topic" with the following. The committee hold at least 2 meetings on this topic, starting with the CEO of Canada Post, so that the motion in its entirety would read that the committee undertake a study on the sustainability of postal service in Canada's rural and remote communities, that the committee hold at least 2 meetings on this topic, starting with the CEO of Canada Post, that the committee invite the CEO of Canada Post, President of CPAA, and Minister of Public Services and Procurement, and that the committee produce a report and table it in the House.
Excellent.
Mr. Sousa? Oh, sorry, does anyone want to speak on this amendment? Yeah. Mrs. Block, then yourself, Mr. Pulaski. Or Mrs. Vignola, then yourself, Mr. Pulaski.
Ce sera
I'll be very brief. 2 meetings means 4 hours. That means a third of what my colleague is proposing. In my humble opinion, that is not enough because rural regions in Canada are numerous and they're facing several problems, whether that has to do with undelivered medication. We've been talking about this for years and years and years, and there's always a reason to put it off. So 2 meetings, 2 2-hour meetings, 4 hours. If we want to be able to find solutions that are viable in the long term for these people, I would humbly suggest that there be a very friendly amendment, which would mean 3 meetings, if not 4. So I would suggest 3, if not 4. Also, I think it is extremely important to be able to consider this situation in depth because there are areas where postal codes are the same and addresses are the same, and they don't even live in the same village necessarily. And what that means is that something might happen, there might be an emergency, there can be deaths because of this confusion. And so Canada Post also has to deal with that situation. So it can't just put this on the shoulders of municipalities. It can't just be up to them. So yes, there have to be meetings on Canada Post, and I would suggest a friendly amendment whereby that 2 would be changed to, at a minimum, 3. Thank you.
Mr. Pulaski?
Yeah, I wanted to just voice my support for Madame Vignola and Mr. Bachrach's proposal. 2 meetings of 2 hours is not enough. I know for people living in urban areas, you hardly think of the mail, but having grown up in the country myself, and I know every morning going down to the bottom of the driveway and checking the mail, and so much happens in the mail. So I agree. And the big question is, how can you make it sustainable, given the fact that there probably isn't any profit and money to be made in this, but it's an important public service. And I think to properly canvass the issue, we need more than 2 sessions. And I'm going to call for a vote. Or what do you guys want?
Got an amendment.
Okay.
Sorry, it's Mr. Bachrach, then Ms. Block on the amendment.
Thank you, Mr. Chair. I appreciate that my colleagues have substantive thoughts on the motion and on the issue that we're debating, which is great. It means it's going to be a good study. I would like to have the hours of witness testimony expressed as hours of witness testimony as opposed to meetings. We eat up a lot of time at meetings dealing with other matters, and it often cuts into the testimony of witnesses. I had proposed 12 hours of witness testimony, which is 6 meetings. I'd be willing to accept 4 meetings worth or 8 hours of testimony. Perhaps that's a compromise we can reach. My concern is that we have 4 minutes left in this meeting, and I don't believe that we're going to get to a vote either on the amendment or the main motion. So with that, Mr. Chair, I believe it's in order. I will move that we postpone this debate until February 7th at 4:30 p.m.
We're trying to get a few extra minutes to continue.
If I may,
hold on just 2 seconds, please. Yeah. You know, we still have a, are you looking to, I'm sorry, to adjourn the amendment, a vote on the amendment?
Point of order, Mr. Chair. I can clarify my motion. I believe it's in order, and we can confirm with the clerk.
Could you confirm, repeat again, please, what your motion is?
The motion is to postpone to a certain time, that certain time being February 7th at 4:30 p.m.
I think you can adjourn the amendment, vote to adjourn the amendment.
Could we ask the
Could it
clerk
be done?
for procedural advice on this? Because I think a motion to postpone until a specific time is in order, is not debatable, and must be put to a vote immediately.
Let me just,
It's a point of order on
let me deal with it, please. I disagree, but let me, as you're requesting, do so with the clerk. Yeah. No, the clerk is saying what I was saying. You cannot do that. You can move to adjourn to a vote on the amendment, but you can't suspend to a certain date or put conditions on it.
A question through you to the clerk.
Sure. Go ahead.
At other meetings, we have had motions to postpone debate until a certain time. That is a dilatory motion that is not debatable and needs to be put to a vote. Is my understanding unclear?
I think you may be wrong, but I will.
Okay, I'm open to being wrong.
I will have the clerk address it. Just go ahead.
Thank you. If a motion has a condition attached to it, then it can't be moved while there's a motion on the floor. So if it doesn't have a condition, it's a dilatory motion. So if it was a motion to adjourn debate, but if it has a condition attached, it has to be handled differently.
Ask a follow-up question to that, just for my edification.
Please go ahead.
A motion to, my understanding is that a motion to postpone to a specific date or a specific time is a dilatory motion. How can you move a motion to postpone to a specific time without specifying what that time is?
You can't move because that has a condition attached to it. So the clerk's rolled and I've rolled in. You're welcome to. We can try and get a few extra minutes in, but I'm pretty sure offline, if you discuss it with your colleagues, we'll probably come up with something because we seem close to 3 or 4. I think one was at least, and we quite often do at least motions so that we have at least 3 meetings or 4 meetings. I think you probably find agreement to do that, and then we can wrap in the other one.
Point of order, just if that, like the process, Mr. Backberg.
If it's discussing the procedural, no, I think I've rolled on, and let's move on. Did you want to move? We can have the motion to move or to adjourn Ms. Block's amendment. Move to adjourn the debate on Ms. Block's amendment, and then we can finish up. And then I imagine that knowing the committee, if you talk offline, I think you could probably come to, there seems to be close agreement with 3 or 4 at least to have the motion like that. And then we could probably have a new one put on order today for Wednesday, if you wish.
I'll move to suspend, and if we vote to suspend, then we will pick up precisely where we left off at our next meeting. My concern is that we pick up where we left off at our next meeting. I know that's not always the case, and so I just want to be specific about it.
So you're looking to suspend the debate on the amendment?
Suspend the meeting.
Suspend the meeting. I have a solution. I suggest that we just adjourn. Wednesday, our witnesses have stated they do not, they're not available. So we will have committee business. So we can finish this off on Wednesday, since we have no witnesses.
And Mr. Chair, I keep trying to make motions, and I'm unclear whether my motion is in order. Can you rule on whether my motion to suspend the meeting is in order?
It's been suggested that it's advice I'm receiving from the clerk is to move to adjourn it, but I will confirm with it. Hold on 2 seconds.
Thank you.
Move to suspend. My clerk has never heard of that, but she will double check.
Point of order, Chair. I wonder if the committee would agree if we don't have our current the other intended witnesses available for Wednesday, that we do set aside some time to continue with the lost time for questions to Mr. Lafleur, as well as some time to conclude the matters of committee business, including Mr. Bachrach's motion. I think it's reasonable for that work to finish on Wednesday. It could even be the first item on the agenda, but I would like to have Mr. Lafleur back as well.
I don't think we got that far with Mr. Bachrach.
that we were quite limited, frankly, in our ability to in our time to ask questions because of some of the other interventions.
I do have an answer as well. Clerk is stating it's not a dilatory motion. You can't move to suspend. So I suggest, as I've suggested,
Point
we
of
move
order,
to
Mr.
it.
Speaker.
Yeah, just give me 2 seconds. Let me finish, please. I'm going to suggest again, perhaps if you wish, as I said, we do not have witnesses Wednesday. We can continue this Wednesday under committee business. And then perhaps we'll discuss about Mr. Lafleur for our second hour, our 40 minutes that we had for questioning, or
On this issue?
if we're fine with that. But go ahead, Mr. Sousa.
Yeah, on this issue, do we need consensus to adjourn? Or given that we have ongoing engagement, we have an ongoing motion, we have an amendment to the
Well, we
motion,
have-
and do we need consensus now, or can we suspend, or do you have the right to drop the gavel without consulting with us to provide for
We do
suspension?
have a speakers list on Miss Block's amendment. She was next. Mr. Backrack has made several attempts. We were trying to accommodate him, but none of them were in order. So really, I was suggesting that we have agreed to an adjournment, but Mr. Backrack doesn't appear to be in agreement with it. So we are probably about another, we're going to lose our resources about another 4 or 5 minutes, but we do have a speaking list, and Miss Block is on.
But I'm trying to understand this procedure now. If there is no consensus to adjourn, we cannot adjourn.
If we don't have resources, we adjourn. I adjourn the meeting. If we cannot continue with
But it would
without
suspend for the
resources.
next meeting, right?
I just adjourn it.
Can you
Go ahead, Ms. Block.
Monsieur le Président, est-ce
Thank
qu'on
you
est vraiment
very-
en train de s'astiner à savoir
Are we truly arguing about whether or not we're going to adjourn? And can we not just simply decide?
Je suis désolée, mon interprétation ne fonctionne pas.
Are we truly arguing over whether or not this motion has been properly worded or not in order to be able to adjourn? Is that what we're all arguing about? Are we going to adjourn? Well, no, we can't because it wasn't worded properly. This doesn't make any sense. We have 3 minutes left. We're going to have to adjourn. We're going to have to talk about Mr. Bacharach's motion. I think we all agree on that. I have no idea why we are losing all this time.
Your colleagues, but if we adjourn, Mr. Backrack can certainly start the next meeting with a motion to reintroduce the motion, and we can discuss it then. Mr. Backrack is trying various procedural issues to try and extend it, and I appreciate that. But it looks like we're going to probably continue it anyways Wednesday, whether Mr. Backrack likes it or not, through the procedure we're doing. Well, that's kind of what we're at. We do have about 2 or 3 minutes. We do have Ms. Block on the speaking list on her amendment. Then we will run out of time. We will adjourn. But I'm suggesting that because we've lost our witnesses Wednesday, we'll set aside committee business to continue this. And I will encourage Mr. Backrack to talk offline with everyone, with the vice chairs, so that we can come up with a simple agreement for the motion, because this seems to be generally supportive. Ms. Block, go ahead.
Thank you very much. After all that, I would recognize your very astute observation that I included in my motion at least 2 meetings as opposed to a minimum of 12 hours. Representing a very large rural riding in the province of Saskatchewan, I do recognize the issues with postal service in rural Canada. That is why we are open to this motion, to this study, but wanted to encourage us to start with 2 meetings, at least 2 meetings, and then go forward figuring out where we would go from there. So I look forward to any offline discussions that Mr. Backrack would like to have with us, his conservative colleagues, to see if we can come to some sort of agreement on the length that this study should be. Thank you.
I don't know yet. If there's no one else on the speaking list, we can vote on Ms. Block's amendment. Recorded vote, colleagues, on Ms. Block's amendment. Should read it back to Mr. Backrack, or do you have it? Do Jeff, that you
Yep.
can-
The committee hold at least 2 meetings on this topic, starting with the CEO of Canada Post. Mr. Pulowski,
Against.
Mr. Baines,
No.
Mr. Jarari,
Against.
Mr. Kamiritz,
It's Mr. Kazmierczak, and it's no.
Point of order, it's Kamiris.
Mr. Souza,
No.
You gotta laugh at it.
Ms. Block,
Yes.
Mr. Jennis,
Yes.
Mr. Brock,
Yes.
Madame Vignola,
No.
Mr. Bachrach.
Opposed.
Amendment is defeated. Colleagues, we're basically out of time. Quickly, can we, a couple things I'm going to suggest. One, that we adjourn and continue this and hopefully sell it early Wednesday with, again, Mr. Bachrach, I suggest you chat with everyone. We get your friendly amendment set up so we can move it quickly, because it sounds like we're almost there. But before we do that, adjourn, I'd like to see if we can, if we have agreement on that, we can push the Canada Post back off to Wednesday and get it settled down. But also before we adjourn, I think I understand from the Liberal side there's consensus to distribute the report just to the MPs and keep confidential. So if I want to settle the Canada Post one and then get agreement on that one, and then we can adjourn.
Mr. Chair?
Yes.
Yeah. P9, not an issue. I'm not 100% what
Or
this
we can-
confidential means.
Well, we've had, when I say confidential, we've had stuff in the past, like the McKinsey documents, for example, were shared with us, but we agreed that we would not release them. Like the stuff from McKinsey itself, we agreed we would not release them until McKinsey had an opportunity to come explain to us what they'd like to see redacted. So that's what I mean. I want to make sure that they stay.
P9, yes, confidentially. I don't know because we've already released half of the some of the key reports.
Can
so on the P9,
can we agree
yes.
P9 and then we can keep it among MPs until our next meeting and discuss further?
Just to P9. That's the extent we're going to agree.
The other option is printed copies, but I suggest the SharePoint to the MPs.
Appropriate to send it just to the members, but you don't have consensus to adjourn. I think we do want to suspend, just continue on with our conversation
Yeah,
next
can
week. So
can we just deal with one thing at a time, Mr. Souza?
Oh,
So
absolutely.
Can we just, just quickly, can we just agree then?
Yes.
I want to get to that first, but it has to be one thing, then the next. We can suspend or adjourn. It's going to be the same result Wednesday. We'll continue, but again, I strongly suggest, Mr. Bachrach, you we seem close, but that we can get your friendly amendment and some of the other issues. And I think Mr. Souza or someone else had amendments proposed as well. That they just get them all ready so we can put them to bed early Wednesday. So I'm happy to suspend and continue. Happy to adjourn, and you can reintroduce the motion the first thing Wednesday to continue as I suggested. It's up to you. It's the same outcome, so you can decide. But before we do that,
You keep, Mr. Chair, you keep looking at me like you want to know what my intentions are, what my desire is, and I feel.
trying to get consensus among the room.
My understanding is that adjourning and suspending are two different things and have two different effects. One ends the meeting, and at the next meeting there will be a new agenda set by the chair, and we will proceed according to the agenda. Suspending indicates that this meeting will continue in the next time slot for the committee's meetings. That's my preference. That's why I moved a motion to suspend, which I was told was not in order. That's why I moved a motion to postpone until a certain time, which I was told was not in order. I've kind of run out of motions. I'll just defer to your will as the somewhat arbitrary chair of this committee, and do what you will.
I'm going to take offense at your arbitrary. I'm happy, colleagues, if you want to be like other committees and stick to every little point, and we'll get nothing done and run it that way. Or we can have one where we can agree to do stuff, but that's the will. suspend will be fine, but before we
Point of order.
suspend,
Point of order.
you see, this is, well, this is what you wish, Mr. Backrack.
Okay, so I know the standing orders very well, and I just say that following the rules is important to me, and the rules provide that when debate is adjourned, either through the adjournment of debate or the adjournment of a motion, a member can, after any time has passed, move a dilatory motion to resume consideration of the original motion. So Mr. Backrack has that right. Regardless of whether we suspend or adjourn, he can bring this back
That's not
and
a point of
request that the
order.
committee
We're
at
gonna
any
move
time
on,
of his
Mr.
choosing.
Genuis.
The motions.
Yeah, okay. Before we suspend, I get understanding we're going to suspend, which is fine, but before we do so, I will ask that we have UC then that we will distribute that on a SharePoint to the P9s only.
Yes.
Perfect. We have agreement for that, and then if we have a motion to suspend, and we seem to have agreement on that. Thank you, colleagues.